Welcome to the second online workshop on IP management. Today with me, Laurence Morel-Chevillier, IP and Brand Protection Director at Bulgari, and Elio De Tullio, founder and managing partner at De Tullio & Partners and ISME board member. Today, we are going to discuss a topic and the relationship between intellectual property and brand management. From a SME point of view, is a very important topic since we know that SMEs cannot pursue a cost leadership approach because they don't have the economy of scale of larger firms, and they have to avoid the so-called commodity trap coming from low-cost products manufactured in emerging countries. Therefore, it's better for SMEs to pursue a differentiation strategy. And here, brands and trademarks may indicate firms' innovativeness, positioning, and their uniqueness. We know that what a brand is and the main definition, a name, a sign or a symbol, or a combination of them to identify the maker or the seller of a product. But beside this definition, I want to highlight from a marketing point of view that brands are something more. Customers attach meaning, values, attributes, a relationship. Brands can show the quality, the history, the background of a product. Therefore, we can say that customer in buying a product can also express themselves. So brands are very important from a decision making point of view. We know that thanks to brands, customers avoid the comparative analysis with other brands. Customers are not able to, and sometimes they don't want to analyze all the information and the available choices in order to make their own decision. Instead, if we want to recall Herbert Simon, the Nobel Prize, Herbert Simons, they are characterized customers by unbounded rationality. They choose through heuristics, rule of thumbs, they choose and purchase, make emotional decision. And this is the value from a marketing point of view of a brand. From a financial perspective as well, another topic that we will touch during this training course organized within the IP for SME project co-founded by the EU IPO and thanks to the European Commission support. We are going also to look at the financial aspect of and relationship with intellectual property. And from a financial perspective, brand often are the major asset of a company with a value exceeding the value of all other tangible assets listed in the balance sheet. If you consider that brands such, the famous brands such Amazon and Apple have a value of more than 600 billions and above. So this is why we would like to discuss and to analyze this topic with our expert. And without further delay, I would like to start the discussion with Elio De Tullio, asking his insights on why and it's so important to register a trademark to protect a brand for a company.
Thank you, Giovanni. Thank you for your inputs. Very happy to be here. Well, I always use this story. Brands and trademarks are for products and services what, the first name and the last name are for babies. So when a baby is born, you need to register his or her first name and last name at the registry office. Before make him or her going around in the world. So that is what we need to do for our brands, for our products and services. They must go around the world and be identifiable. I mean, the matter why it is very important to register a trademark is to make your products and services, if you are an SME, to make your products and services recognizable among the other products and services, of course, provided that they have special qualities. And the other function of trademarks or brands is to create a connection between the products and services and the producer, those who are the providers of the services. And so at the end of the day, a brand, a trademark, creates a special loyalty between the user, the client, and the provider, and the producer. And that is why it's very important to make your company recognizable on the market, make your company preserve the competitiveness achieved through the quality of products and services sold on the market. And of course, this incentivate any attempt of imitation or counterfeiting or copying without investment by others. Because of course, I always say, if you are not successful, don't worry about intellectual property. You will not be imitated, you will not be counterfeited. But if you are successful, and I believe that your SMEs, if you are an SME who like to be successful, then there will come problems. And so it is a way to prevent to be copied once you are successful and your products and services are sold, are bought on the market for their quality and for the special loyalty created with consumers. Then, of course, there are a lot of other practical reasons. Of course, you need to, only if you have a trademark registered, you can have access to some remedies provided for by the courts, for instance, seizures of products or cease and desist orders or other orders that can, let's say, punish the counterfeiters and can avoid the imitation of products and services. You can, of course, avoid avoid being copied on e-commerce platform and others. So, and then, of course, last but not least, registering a trademark will allow you to authorize third parties to use your trademarks even in jurisdiction in which you are not, let's say, physically based. For instance, if you register a trademark in another country, you can identify distributors or a licensee, and you can ask him to promote your products and services in that country, authorizing this company, the licensee, to use your trademark in that country. So there are a lot of very important reasons. Of course, the first reason is to preserve the competitiveness achieved by SMEs in selling and promoting their products and services.
And thank you, Elio. And having highlighted the main advantages for an SMEs to register a trademark, which are the best ways to choose and select a brand with the aim to succeed in the market?
Well, this is a very good question, because I mean, from our perspective, from our point of view, SMEs usually try to identify very commercial brands, sometimes composed by descriptive descriptive words. I mean, words that contain descriptive terms or terms that cannot be monopolized, like, you know, geographical names or names of type of products or generic names, common names. And of course, this is reasonable because, of course, they would like to be immediately identified by consumers. But those descriptive names, common names, generic names cannot be monopolized because they belong to everybody. And so one of the key points to address to SMEs is to make them aware that trademarks and brands must be distinctive, not descriptive. So distinctive means then that generally speaking, they cannot be, they can refer to products and services that would like to be identified by those brands. And so generally speaking, they should not have any connection with those products and services. So they must be fanciful names, very, you know, names of fantasy, or new words created ad hoc from the commercialization of those products. And so this is the first point. So the name should be, let's say, quite catchy in terms of the possibility to grab the attention of consumers, but at the same time should be legally strong. And how can I identify a name, a brand that is legally strong? Of course, I can use trademark searches. On the EUIPO website, you will find the TMView, that is a free search engine, a free database for carrying out a preliminary trademark search. And this is fine because SMEs can have a first look at the names and try to see if there are some identical names for the products and services they are going to sell. But of course, sometimes data should be interpreted. And so our suggestion is always to be supported by an IP expert that can interpret the data according to the goals of the SME and, of course, the jurisprudence and the practice. And so the database and the trademark search can give SMEs suggestions about the two legal requirements for making a trademark valid. So the trademark must be new, of course, novelty, and the other is the distinctive capacity. So if the trademark is new and has distinctive capacity, so it's not descriptive, it's not generic, it's not a common name, it's not connected to any geographical name, then the trademark is a strong trademark. And then the registration process can start. So at the end of the day, the magic rule to select a successful brand is to consider the potential market, the potential consumers to which products and services have to be sold, but at the same time to invest money in strong names, and these strong names can be identified only through, let's say, a careful analysis of database in order to avoid potential interferences. For instance, if you start launching a product on the market, and then the product is identified by a common name or a generic name, or even a name that is not new because there is a prior trademark already registered in the database, these trademarks and these products will start with, let's say, under a bad star, because of course they can face immediately potential problems of registration. They can receive office action by the trademark offices, provisional refusal, or they can even receive a cease and desist letter coming from competitors that complain about the similarity of the trademark of the SMEs with their trademarks. So it's always better to start, the path of commercialization with the right step, the right first step, and the right first step is to identify a very good name that let's say make both the needs in place. I mean, so at the same time should be a very good commercial name, but at the same time a very strong on the name on the legally point of view.
Okay, and then once you have identified and select a strong brand, from a practical point of view, since we are speaking about small businesses, and from a practical point of view, which are the main steps to follow to register a trademark?
Well, thank you for this question. Of course, you can refer on this. You can refer to also to the UIPO website, where there are a lot of tips and suggestions in order to, let's say, get information about how to register a trademark. Of course, it's also very clear from the UIPO website that professional support is needed. But of course, you can, if you are an SME, you can get first preliminary information from the UIPO website. I would say that the first step is always the classification. And the classification is to identify for which products and services you would like to use your trademark. Of course, you don't have to think about only to your actual business, your current business, so the business you are carrying out today. But since trademarks last 10 years from the first filing, they can be renewed indefinitely. So you need to think about also the potential products and services to be sold on the market from your company in probably 3, 5, 10 years. You should find a good balance between, you know, let's say, having a quite wide protection of your brand for even, you know, future products and services, and let's say your budget, because of course you are going, if you are an SME, you are going to pay the protection according to the number of classes you are going to claim in your application. So, I mean, you should find a good balance in the classification. So the classification is the first step, because then, based on the classification, you can carry out the search, I mean, the trademark search, in order to check the legal requirements, the novelty and the distinctive capacity of your trademark. Of course, you cannot monopolize as a trademark that is unlawful, that contains bad words or other words that are not, let's say, commonly accepted as let's say, lawful. But having said that, the two legal requirements that are very important are novelty and distinctive capacity. So the first step is to file the application, possibly in the country of origin. So if you are in Italy, you can file an application in Italy, but the best value for money solution is always to file an EU application. I mean, an application for protection before the UIPO, the EU Intellectual Property Office of Alicante. Then, starting from that date, the date of the first filing, you will have 6 months priority in order to extend your protection at worldwide level in any country of the world that are member of the Paris Convention, that is a convention signed in 1883. So think about how old is the intellectual property system. And so you can extend your protection in any country of the world, apart from some countries like Myanmar, that is not part of the Paris Convention, claiming as starting date of the protection, the date of the first filing in the country of origin. So making an example, if you file an application today that is the 10th of July 2024, before UIPO, you have 6 months until the 10th of January 2025 in order to claim protection in the United States, China, Japan, and Australia and other countries. But the date of protection will start on today also in these countries, provided that you have filed the application according to the international convention or through the national path. And then, of course, you need to follow the story, because sometimes you receive provisional refusal, office actions, then the trademark is published on a bulletin, and anybody that is any company, any entity that is the owner of a prior trademark in the countries in which your registration has an impact can file an opposition. So you need to, I mean, the preliminary check, the trademark search is very important also in terms of mitigation of risks, to understand if, at what extent you can go ahead with your trademark and how much budget you should allocate for any kind of further action in order to defend your trademark, but also your registration process. I don't know if it was enough clear.
Obviously,
yeah.
If there are questions from all the participants, I invite you to use the chat box below, and I will collect the questions for our experts. So please, if you have any comment or any questions for our expert, do not hesitate to use the chat box.
Probably, Giovanni, I can add one information that is very important for SMEs. It is still in force. I mean, it's still valid. This program that is the SME Fund of UIPO 2024 that allows SMEs to receive a reimbursement of up to 1,000 euros for official fees related to EU trademarks, EU design, and also for some, let's say, fees related to patents now. So if you check on the UIPO website and you just Google UIPO SME Fund 2024, you will find information about the reimbursement available for SMEs. And so you can receive a financial support for registering your trademark. I mean, stay tuned because this measure will be valid only for other few days, and probably then it will be over.
Very useful suggestion. Lawrence, speaking about brand, and given your background and experience with multinational enterprise and larger companies, which is the value for them? How much is valued a brand within a big company such as the one you are working for? Please switch on your mic.
Yes, better like that. Thank you, Giovanni, and good morning, hello, or good afternoon to everyone attending. Well, yes, the value of a brand is definitely something strong, something important. For Bulgari, it is, for sure. And don't forget that Bulgari, yes, is a big company, but it all started with a very tiny one. Because the founder of the company, Sotirio Bulgari, a Greek person, was a silversmith, and he was working by himself in a very small shop. And then he traveled to Rome. Traveled to Rome, where he opened a very small shop at the very beginning. So it was basically an SME at the very beginning. So for sure, the years have passed, and this was in 1883 when the first shop and store was opened in Rome. And now a lot of a journey has been made, an extraordinary journey, where today we can say, and I can say as an IP in-house lawyer of Bulgari, that the brand is a promise. So it's not just the fact that Bulgari defends a brand, Bulgari brand. It's all about an experience that the brand wants to give to the client, to the final customer. Because we are explained and taught, and yes, I would say explained very well, that our best and our prior client is the customer. So we have to do everything which is necessary in order that the customer is happy with the service and the product he will find in our company. So it's very clear, and we see the values of the brand written on the walls where, and I will read them to you, because the core belief is that people make the difference. Be innovative and creative, deliver excellence, cultivate an entrepreneurial spirit. So with these sentences, which are our core beliefs in a house, you see behind that a lot of values. And for sure, one of the values that Bulgari is defending is transparency, also sustainability, themes which are nowadays absolutely very trendy, but very, I would say more than trendy, for sure, very extremely important, especially for the Gen Z generations. They very strongly believe in sustainability and innovation. You see also in the core beliefs of Bulgari, innovation, be innovative and creative. So the values of the brand are based on the great story of Bulgari, of the heritage, of the craftsmanship, but turned up to the future, to innovation, to creativeness. I've seen, and I will explain a little bit more about that, since Bulgari has built around that. We have a code of conduct, which is applied to all the suppliers who are dealing and working with us. Code of conduct where our values, our high values, are explained very much in detail. Bulgari has created very recently a foundation called Bulgari Foundation to explore, let's say, all those values. So can you shut the door, please? Thank you. Sorry for that. So one of them is art, and Bulgari is making a lot of activities around that in Rome. Bulgari has restored the Spanish Steps, etc. Bulgari is working on different, let's say, cultural environments and on the history of Rome, because Bulgari was born in Rome, and also is concentrating on education. There's a big project around Save the Children, where a part of the money collected from the sales of those jewels, there are 2 types of jewels, are let's say given in for the Save the Children. And of course, also Bulgari is developing a school around craftsmanship, which will be opening in the coming months. This is all about value, and I was happily surprised to see very recently, it was yesterday, and by chance I bumped into that, the WIPO Global Awards for SMEs. So WIPO will be awarding some SMEs based on their involvement with intellectual property. So this is pretty much very much in relation to what we are talking about today. And I had a look at the 25 finalists of this award. You can find them on the WIPO website. This is very interesting because I don't have all of them under my eyes now, but what I remember by seeing that is those 25 finalists do come from different countries of the world, including Italy. Sorry, I mentioned that because there are some Chinese companies, but there's at least I saw one Italian SME. They all have a brand. They all have a brand, and a nice brand. I could see that the name and their brand is nice. Some of them are related to the products or services that they offer, but they have put maybe a device, a color. There's something which makes those names quite distinctive and recognizable, leaving anyway a link and a little bit idea of what they deal with, which is, and to go back to what Elio was telling you before, which is, I think, sometimes important, just to orientate the customer and to say, oh, okay, nice, this name, okay, is not maybe super distinctive at the very beginning, but at least I have an idea of what the company is dealing with. And I think that for SMEs, it might be quite sometimes important. So also because a brand is evolving, it can be very, very descriptive and not so distinctive at the very beginning. But then if you know how to exploit it and how to deal with it, it may become very strong. And to get back also to those 25 finalists of this WIPO Global Awards, what I saw is that all of them have big values. They are basing their activity on some big important values. For example, I saw that quite a lot of them were dealing with health matters. So they have put in place a system for cancer recognition, something like that. Others on environment. And I think that the Italian SME is dealing with an umbrella, which is made of a particular fabric material, which is absolutely environment safe. So definitely values are important for the brand, even more today, where we get back a little bit to the important things: transparency, sustainability, because we can't do otherwise. Giovanni, we can't hear you. You're mute.
Thank you. Thank you for describing and sharing your insight of such iconic brand as Bulgari is. Speaking about it, and being a director of IP and brand protection, which are your main challenges today?
So I think that the challenges of a big company are also common to SMEs, most of them. So I would say that a brand needs to be true and to remain true to its values, because it's good to say that you value on sustainability, on transparency, etc. But at the end of the day, if you are not transparent, if you are not sustainable, you will be not going in the right direction, and you will be pursued somehow by the customer. They won't be happy. So we always remember that the customer is the one that needs to be satisfied. So the challenges are in a brand. This is the main challenge, I would say, and also in today, in the middle of this big competition that exists between companies, there's a lot of choice for the customer. The customer has a multitude of choices for any product, for any service. So your biggest challenge will be to stay unique and to find your place in the middle of that big choice. So in order to stay unique, you'll have to offer a product or a service which is absolutely reliable, of good quality, where you can start a relationship, a frank relationship with your customer, a transparent relationship with your customer. And of course, as an IP in-house lawyer, this means that this reflects how this will reflect on the IP activity. It means that you need to have a strong portfolio for your brand or your designs or your patents if you deal with innovation. And you have to get that strong portfolio, but also to have it very flexible, because you'll have You have to deal with the management, with the brand, with the business units, with whom is creating, producing the products in order to follow. Because maybe they can tell you, oh, tomorrow we'll invest everything in Africa. Okay, maybe the portfolio is not adjusted enough to that part of the world, and you'll need to modify your strategy. This is one point. Also, you'll have to move your approach, your traditional approach to IP, especially when, and this is what happens in Bulgari, where there's a lot of innovation. So the company wants to create innovative experience for the customer, for the client. So it means using the new tools that are at disposal of everyone today. For example, of course, artificial intelligence. So you can imagine that an IP in-house lawyer dealing with that needs to open his eyes and to pass from a traditional approach to IP to an innovative one. What does it mean? It means first dealing with contracts, maybe something that the IP lawyer was not dealing with in the past years, with contracts with artificial intelligence to understand, first of all, how it works really in detail, to support the business, the company, in order that they can go around and develop in an innovative way and in a safe way, talking about intellectual property. Getting back, maybe if I can just add to strategies of protection, I would say that when you are in SMEs, you have to make priorities, because maybe, as Elio was saying, you don't have enough budget to protect all over the world. So you have to analyze very deeply where your business is directed to. You want to stay in Europe? Okay, you know that your countries are 27 or 28, depending. Europe, it's not only European Union. So you will focus on that. And then you will also have a look at the countries maybe where counterfeiting is higher. I think that you cannot ignore China today, even if you're not supposed to deal a lot with China. China should be quite an obsession, in the sense that as soon as you have your brand, file it in China before anyone else will do that. Because in China, if you don't have the trademark, you will be blocked in many tasks that maybe tomorrow you're not planning this year to go to China, but maybe in a couple of years you will, and it will be too late if someone has already filed your brand there. So China is absolutely something to take into consideration, and also make a priority list. We call it the safe box list in Bulgari. So safe box means Europe, means US, means China and Middle East, let's say. Once you have filed and protected your brand in, let's say, in these 5 areas, you have obtained a good protection. And then if you want to go deeper, because you will invest in particular in one specific country, then you can build around a little bit more. And also don't forget about some tools, some very useful tools that were born in very recently, which can be a plus at a very low price. We bumped into that last year, and to be frank, it's a tool like there exist many. They consist in time-stamping your creations, whatever you have, a brand, a design, a drawing which is not finished, a project of layout of a store, something dealing with your patent that you have not finished yet, but you have built a little bit all of what you will put in that. You just put that into a kind of software. It's a software which is linked with a blockchain. So you will put a date, a name on that paper, whatever, drawing, whatever there's no limit in the form. And it will allow you tomorrow, maybe if you you see that someone has used what you have already created, you can show it. Look, it is mine. I've created that on the 1st of January. You came on the 3rd of March. I was before, and you can obtain, it's not an IP rights in the sense that it's not as strong as trademarks, designs, etc. But at least, especially today in the artificial intelligence, artificial world, it can be very useful also if you use artificial intelligence to prove that you have put humanity in what you have created. And tomorrow, it might be that you will be recognized a copyright on what you have created. So, and this tool doesn't cost a lot. It costs maybe 5,000 per year without any limit in the things that you can put inside. So I think that is a useful tool for SMEs to complete protection.
Thank you for suggesting hands-on tool and methodologies. You mentioned that in the luxury sector, especially in the luxury sector, counterfeited goods are a huge threat. How do you deal with them?
So counterfeited goods, first you have to find them. Where do you find them? You find them offline, so on the territories, at the borders, and online. So in order to address that, you first have to register your brand at the borders. So this is easy with the customs. You can apply your trademark in the customs databases with some information on how to recognize your product from that of a competitor, and you will put your titles inside so that whenever some goods are seen by the customs officers or around the world, they will contact you and you'll be in position to say and to confirm this is fake, this is genuine. And if this is fake, the customs will stop. And you also have, in many countries, the possibility to ask for immediate destructions of the good. So this is a first point, very important to control at the borders. Then on the territories, we have teams of investigators making surveillance on the markets, making surveillance on the big places known as places of gathering of fakes. And we organize raids with the local police. And this allows us to have and to maintain the market quite clean. This is not an easy task. This is a little bit, let's say, something which requires investment in terms of, depending on the territory you're talking about. If we are talking about only a country, this is one thing. When you have to deal with the whole world, you have to make priorities and decisions on where to focus first, because this is expensive. The control and the surveillance is continuing and is going on, ongoing. And the benefits can be interesting if the control is ongoing and continuous. And I've talked until now of the offline, of the real world, but as we all know today, the online world has become one of the most important, and this is the place where fakes are circulating the most. So how to deal with that? I think that today it's very possible to, by ourselves, to deal and to, SMEs may have limited possibilities to deal with that. we have, for example, providers specialized in analyzing what they find around on marketplaces, and they will make takedowns. We destroy the windows, the visibility of what we find online, fakes. In order to do that, you have to be very knowledgeable on how to recognize your products from the others, to give such information to the provider or the marketplace directly, because most of them are now organized with some procedures that you can have access to, where you can indicate to them, look, this is a fake for this reason, this is my trademark, please shut down, and they do. It takes some days, some weeks, depending on the platform we're talking about, but this is feasible. This is feasible also because today most of the marketplaces have organized themselves in order to allow this. So this is how we deal with fakes mainly. When we try also to go from the online to the offline as much as possible, in order that whenever we find a repeated infringer online, we try to build investigation in order to find the place where the goods are really coming from. Not easy because most of the time, whenever we send the investigator at the address, at the Chinese address that was mentioned on the online world, there's nothing. This is a fake address also. So again, very challenging thing to do, but we are successful sometimes, and it's good to see that the chain can be taken until the source, but it's not always the case.
Thank you, Laurence. Thank you very much. Speaking about online, and time is running, we would like to discuss a little, a couple of things more with Elio. Speaking about online, do you want to add something about what Laurence was saying on specific challenges because of the presence of product in a marketplace such as Alibaba or Amazon, because we know that they contribute a lot to the cross-border export. But are there any IP-related challenge you want to highlight? You are muted, Elio. Pay attention.
Thank you. Thank you, Giovanni. Well, Laurence was really clear, and she already anticipated several points of this online, let's say, challenges and online actions to be taken in order to reduce, I mean, the risks and also to find some remedies. First of all, you know, the first pillar for any online or offline activity is the IP protection. I mean, you can choose Amazon, you can choose Alibaba or other platform to promote your products and services, to sell your products and services. But in any case, if you would like to, let's say, work on the collaboration platform or this marketplace, you need always to be registered. So you need always to be to have a right that is registered in the country or in the countries in which you would like to enforce them. And of course, once you have your rights registered, you also need to, let's say, prove this registration. So you need to have all the documents in good order. You need to have the certification, the registration certificate. And sometimes, for instance, for copyright, that is, let's say, that theoretically can arise independently from a filing registration process. So it's an untitled rights, theoretically. Then also for copyright, you need to file, you know, the proof of your registration in order to enforce your right. I mean, the registration certificate is always the starting point. The other point to be to clear is that the anti-counterfeiting activities or the detection of potential infringements is always on the shoulder and on the budget of the right holder. So there is no god of intellectual property. There is no Amazon that will, you know, on behalf of you. Of course, if you provide enough evidences that there are some products listed on the platform and you have rights to obtain the removal, then this can happen in on Alibaba and on Amazon and the other marketplace. So generally speaking, the process is not easy, but it's not very complicated. Of course, going before a court is much worse. And another thing to clear is that, of course, you will not receive any compensation of damages if you file these takedowns and you file these complaints before Amazon, Alibaba, and other platforms. So generally speaking, you need to register yourself to proceed with an IPR authentication. So the platform should authenticate your rights, but provided that there are registered rights that you can prove, that you can evidence. And then you should file a submission, you know, also displaying and proving that you know the products, the counterfeited products on the platform are identical or display a trademark that is identical to yours, or a copyright that infringe. I mean, or they are products that infringe your copyrights or your patents or other IP rights. And then if this process, this submission is considered, let's say, compliant with the platform rule, then you know the product is removed. But I would say the first point is always to have your right registered. You have the possibility to prove your right, and this is the main basic point for any online or offline infringement action. I don't know if Laurence would like to add anything about this.
No, true, Elio. Without any brand registered trademark, you go nowhere on the online world.
So, for instance, there are some untitled rights, so unregistered rights, like unregistered design or trade secrets or know-how that are untitled rights, and even copyright, once again, can arise independently from a filing registration process. But in order to file a complaint before these platforms, according to their rules, you need to prove your right, and a registration certificate is needed. So that is why and of course, don't forget also that protection is on territorial basis. So you always need to prove your right in the territory in which the infringement is happening.
Laurence mentioned that China, you have to take into account, to put at the very beginning of your list of countries in which you want to protect your IP. And entering in China, you need to translate your brand in Chinese. And also often SMEs should identify a Chinese partner in order to invest and commercialize their product there. So how to deal with such challenges to protect the know-how within a partnership and to protect your brand and be translated in Chinese characters? Elio.
Well, thank you. Very challenging question. Thank you, Giovanni. I would say if you, registering your trademark in China was not your first priority, and you are already on the market without your trademark registered in China, first thing to do is to carry out the state of the art, because probably somebody else has already filed your trademark or a trademark identical to yours, or the transliteration of your trademark identical to yours in China. And if this is the case, that is already a problem, because this means that if you will file an application before the CNIPA, I mean, before the China National Intellectual Property Administration in China, probably since they also carry out a substantive examination on novelty, probably they will issue a provisional refusal against your trademark, because your trademark will be considered identical to an already existing trademarks in their database. So I would say, first of all, if you haven't registered the trademark, your trademark in China as a first priority, please carry out a preliminary check, a state of the art, in order to be to ascertain that no anybody else have filed a trademark identical to yours in the Chinese register. After that, of course, if this is not the case, you can file the application. You can, of course, you can use the international conventions. You can use the priority provided for by the Paris Convention, so the 6 months from the priority from the first filing in the country of origin, as mentioned before. Or you can use also a direct filing in China, also claiming priority. But, you know, priority is a matter of opportunity. You can also protect your trademark in China, filing your application after the expiration of the priority. No problem for that. You should consider trademark as an occupation of territories, like a risico. You need to be first as soon as possible in most of the countries of the world, because of course this will be considered a mitigation of risks to be interfered by anybody else. But anyway, so another thing is to transliterate your, of course, to check if your name, your trademark has no negative meanings in the transliteration or in the local language. Of course, we are talking about China, but this is valid also for other Southeast Asian countries. Of course, in other countries that do not adopt Latin characters, like Russia or like other countries, I would say also Greece. I mean, Greek language is not does not adopt Latin characters. And but in particular in China, you need to transliterate your trademark in a Chinese language, in Mandarin. And the transliteration can also refer to, let's say, a not literal transliteration, a conceptual transliteration. Like, for instance, Coca-Cola did, I mean, more than 50 years ago, when transliterated in Chinese, the trademark Coca-Cola, not literally, but according to, let's say, a very catching, let's say, transliteration that is Coca-Cola, you know, to permit mouth to rejoice. And, you know, Coca-Cola is just an example of companies that, let's say, protected their trademark in China since the very beginning. And then I would say, once everything has been, let's say, has been composed in the right way, I mean, you have your trademark in China, you have the transliteration also protected in China, then you can start to enter into negotiations with Chinese partners, with distributors, with licensees. And so you will be requested to, let's say, declarate and warranty your rights, but and you will be able to authorize the licensee or the distributor to use your trademark in those countries, in China in particular. Of course, don't forget to activate the surveillance system, because you need to be aware if anybody else or even your distributor filed an application of a trademark similar to yours. In our experience, there are a lot of cases of distributors that started the filing registration process of trademarks similar to some SMEs trademarks without authorization, just saying to the legitimate owner, I did that in order to help you. So it's very common. And the other thing is use a licensing agreement, but also NDAs, non-disclosure agreements, to oblige your counterparty to respect your trademark, to respect the contract and the contracts according to which you authorize the use of your trademark, and also you authorize the use of other IP rights. For instance, you can use in China these, let's say, upgraded version of NDA that are non-disclosure, not use, non-circumvention, so-called NNN, and they are very, let's say, structured agreements with a lot of clauses already validated by Chinese authorities, by Chinese courts, that of course provided for as applicable law, the Chinese law, and as competent court, the Chinese court, and they can be used in order to avoid the circumvention of the same agreements or the circumvention of your rights in China. So, I mean, there are a lot of tips and tricks to afford the Chinese market, but once again, what I would like to say as a final remark is it is always a case-by-case approach. Probably your company, according to certain condition, needs some specific, you know, specific, let's say, suggestions in order to avoid or prevent infringements in China, or to start a legal action, or to start any remedy in China.
Thank you, Elio. Just a final point I would like to discuss with you. Several entrepreneurs often rely on franchising to start their own business. And we know that the value of franchising come from the brand as well. So, do you have any, both of you, I mean, do you have any suggestion about specific point to consider in signing a licensing agreement or a franchising agreement?
Well, thank you again, Giovanni. Well, licensing agreements do not follow, let's say, template. This is the first point. So there are some internationally validated, let's say, or well considered formal contracts, but at the end of the day, there is enough freedom to include in licensing agreements some specific clauses. Having said that, the first point is let's say, for the licensor, because I mean, we assume that the SME is the licensor. For the licensor to oblige the counterparty, the licensee, to respect its own IP rights, and this is in line with what I was saying before about NNN. So to include also clauses that can prevent the circumvention of the contract. Then, of course, the type of license can be different. You can have an exclusive license, a non-exclusive license, a sole license. This depends on the goals of the SMEs. You can also, let's say, have different agreements on compensation, on you know, the royalty fee. If you like to provide for lump sum or a royalty fee based on net sales or annual turnover or others. Of course, the duration of the contract is also a main point. Don't forget to put the duration of the contract in your licensing contract, because any, let's say, uncertain information in your contract will be used by the counterparty in case of litigation. Of course, you can exclude the right of the licensee to sub-license, and don't forget to include this clause, because otherwise it could be, well, the licensee could consider that he or she can sub-license the right. Of course, there should be also very precise information about the geographical, let's say, borders, the geographical frames of the right, and in particular in China, you should consider if to include or not Macau, Hong Kong, Taiwan, that are, let's say, in the region, but they are considered different IP jurisdiction. Also, I mean, the rights of carrying out audits in the premises of the licensee is a good point. Sometimes it's important, in particular for, let's say, trying to understand if the licensee is calculating royalties in the right way, if it is, let's say, monitoring the market in the right way, because of course the licensee is also the controller of the market. Since you are in Italy, for instance, or in European Union, and your licensee is in China, the licensee will be the one, let's say, if this has been agreed in the contract, will be the one that can monitor the market on your behalf and check if there are possible infringements in the region. And then, of course, confidentiality. Confidentiality is a very important point. Of course, confidentiality clauses are quite well known by SMEs, but in particular in licensing contracts, they should be included. And then, you know, usually the main one of the main points of discussion in licensing contract, as in any other contract, international contract, are the clauses related to applicable law and competent code, competent jurisdiction. What I would like to say on this purpose is only one suggestion. Don't forget that if you obtain an order or a decision or a sentence in Italy or in European Union or in other EU member state, then this sentence should be, let's say, approved in China in order to be enforced against a Chinese entity. So sometimes it is better to start a legal proceeding, a legal action before Chinese courts, and of course, provided that you have been well supported and well assisted by EU attorney and as well as Chinese attorney, rather than to obtain, let's say, an order or a decision in European Union to be enforced in China.
Thank you, Elio. Thank you, Lawrence, for such insightful discussion. I remember all the participants that if you want to know more about IP protection, next webinar is scheduled for the 17th of July on IP infringement. And then after a holiday break, we will have 2 webinars in September. The 4th of September is the workshop on IP and finance, while the 11th of September, we will discuss how to protect IP during the technology transfer process. So please follow us on LinkedIn or contact the Secretariat. You will find the email in the chat box if you need more information on this project and on upcoming initiative. Thank you for your participation. A really good and interesting discussion. Thank you.